So hello friends, welcome to my YouTube channel. Today we will be discussing Section 11 of Indian Evidence Act, also known as Plea of Alibi. So as we all know that Section 6 to Section 55 of Indian Evidence Act deals with the relevancy of fact. It states the condition in which a fact can be relevant. So either it be a motive, preparation or conduct or fact forming part of same transaction. These all facts are somewhat related to the fact in issue or relevant fact, or you can say the fact of the case. But Section 11 deals with the fact which are not in any way connected to the fact of the case. So these are the distinct facts. These are totally distinct facts, and these are not connected to the fact of the case. For example, if a person states that he was somewhere else during the time of crime, he was not present at the place of crime during the crime was done, so it can come under Section 11. He can assert such fact, and he can take the plea of alibi. So alibi is a Latin word which means elsewhere. It is a defense taken by most of the accused where he says he was present somewhere else at the time of crime. So he can take the defense of alibi and state that he was somewhere else at the time of crime. It states the facts which are not otherwise relevant. Certain facts which are not relevant under other sections are made relevant under Section 11. So these facts are not covered. These facts are not relevant under any other section. So let's move on to the next slide. So let us discuss the meaning and scope of Section 11. It states that the fact not otherwise relevant are relevant if they are inconsistent with the fact in issue or relevant fact, or if they themselves in connection with other fact make any fact in issue or relevant fact highly probable or improbable to exist. So the facts under Section 11, if they exist, make the fact in issue or relevant fact either inconsistent, or they in connection with any other fact make it highly probable or improbable to exist or not exist. So there must be a high probability or improbability of such fact to exist or not exist in order to the court to accept it. So it is a residuary section. It is a residuary section if a fact is neither declared to be relevant nor declared not to be relevant. If it may be relevant under Section 11 if the requirement of that section are fulfilled. So this is a residuary section. It is not covered under any section of relevancy of fact chapter of Evidence Act. Discuss some illustrations. So illustration 1 says the question is whether A committed a crime at Calcutta on a certain day. The fact that at the time when the crime was committed, A was at a distance from the place where it was committed, which would render it highly impossible, highly improbable, though not impossible, that he committed it is irrelevant. So A is at a distance from the place where the crime was committed, but there is a high probability that A could come to the place and travel and come within that time period. So there is a high improbability, but there is no impossibility. Such fact would be relevant. The second illustration states A is accused of murdering B on 10th August 2014. A offers to prove that B was alive on 25th December 2016. As the fact is inconsistent with the charge against A, it is relevant under clause 1 of Section 11. So if the person would successfully prove that he was alive on 25th December, then the fact that the murder was committed on 10th August ceases to exist or becomes inconsistent. So let's move on to the next slide. So let us discuss some case laws. In Rajendra Singh versus Ram Ganit Singh, it was observed that the word highly probable are of great importance, and the fact sought to be proved must be closely connected with the fact in issue or relevant fact up to an extent that a court will not be in a position to determine it without taking them into consideration. So the word highly probable or improbable are of great importance. So if certain conditions, certain fact exists which makes it highly probable or improbable of the fact in issue or relevant fact to exist or not exist, then such fact would be relevant. but they must be closely connected with the fact in issue or relevant fact up to an extent that the court would not be able to give judgment without considering such fact. So there may be collateral facts which have no connection with the main fact except by way of disproving any material facts proved or asserted by the other side. So these facts must have no connection with the main fact except by the way disproving any material fact proved or asserted by the other side. So the whole objective must be to disprove the material fact. So let's move on to the next case. In Dudnath Pandit versus the state of Uttar Pradesh, this is most important case. Dudnath Pandit was alleged of murder of a son of his landlord, and during trial pleaded before the court that he was working in his office, which was nearby place of murder during the time of murder. The office was 5 to 10 minutes away by walking from the place of murder. Supreme Court held rule of alibi can be applied only if the distance between the place of crime and the residence of a person must be far enough that it must be impossible for the person to reach within the time period. So it must be impossible for such person to reach at the place during the time of murder, during the time of crime within certain time period. Then only such fact would be relevant under section 11. This was stated in Dudnath Pandey versus the state of UP. So guys, thank you so much for watching my video. Hope you liked it. I hope you would appreciate my effort, and please like and subscribe. Thank you.